5 seconds to go. Start. This appeal is against a final judgment and decree dated 30th October 2017 passed by the High Court of Judicature at Madras, dismissing the appeal suit number 262 of 2011 filed by the appellants and confirming a judgment and order and decree dated 30th November 2010 passed by the principal district judge, hereinafter referred to as the trial court, in original suit number 30 of 2005 filed by the respondent plaintiff for specific performance of an agreement for sale of the suit property. In the plaint, it is pleaded that the original defendant had executed a will on or about 9th May 1984 bequeathing the suit property to the original defendant U.N. Krishnamurthy, since deceased. After the death of his father on 25th April 1987, the original defendant U.N. Krishnamurthy became the absolute owner of the suit property. It is the case of the appellants that on 11th November 2002, while the original defendant was getting the suit property whitewashed, a real estate agent approached the original defendant with an offer to arrange the sale of the suit property at a good price. As per the pleadings in the plaint, the original defendant agreed to sell the suit property to the respondent plaintiff in the presence of 3 persons. The terms and conditions of the agreement for sale of the suit property were recorded by the original defendant U.N. Krishnamurthy in his own handwriting in a letter dated 11th November 2002 given by the original defendant to the respondent plaintiff. It is the case of the respondent plaintiff that the original defendant agreed to sell the suit property to the respondent plaintiff for a consideration of rupees 15,10,000, out of which sum of rupees 10,001 was paid by the respondent plaintiff to the original defendant in advance. It was further agreed between the parties that the respondent plaintiff would get the sale deed registered on or before 15th March 2003 upon payment of the full sale consideration. The agreement was allegedly witnessed by the real estate agent. According to the respondent plaintiff, the respondent plaintiff approached the original defendant with the balance consideration several times and requested the original defendant to execute the sale deed in his favor, but the original defendant kept postponing execution of the sale deed on one pretext or the other. On or about 13th February 2003, the respondent plaintiff issued a legal notice to the original defendant through his lawyer stating that the respondent plaintiff is ever ready and willing to perform his part of the contract and called upon the original defendant to execute the sale deed in favor of respondent plaintiff after receiving the balance consideration. By a letter dated 10th March 2003 sent in response to the aforesaid legal notice, the original defendant denied having entered into any oral sale agreement for sale of the suit property. On 8th October 2005, the respondent plaintiff allegedly approached the original defendant with a request to receive the balance consideration. Stop.